Thank you. You may be seated. Council, that's your turn, isn't it? We are back and it's 11:30.
Thank you, Justice Seneke. I've got instructions and I've been informed that by Thursday she will be fine. So instructions is that client will be here on Thursday and a medical certificate to that regard will be given before this arbitration. That's all. Because the reason was to stand down in order to get the opinion of the doctor so that we don't even stand down to a date wherein we don't know. But in this regard, I've got instructions that by Thursday, she will be ready to come and take off where she had left.
Is this, when are we going to see the medical certificate?
I can make sure that the medical certificate reach your attention not later by the close of business today. But I will talk to my attorney maybe before. It's either on or before the close of business today.
And what do you say we do in relation to your client's attendance?
If as I've indicated earlier on, I don't have any objection if a warrant is issued and be stayed over until then. Since we have indicated that my client is happy to come and proceed with it.
And why only on Thursday? Do you know?
It's as per the recommendation of the doctor. That's what I can say up to so far.
You have been instructed that it is the doctor's recommendation that Dr. Manamela continue to testify only on Thursday.
My instruction is that not only on Thursday, but on Thursday she will be here. We don't know how long will she be required to testify until.
Yeah, you misunderstand my question. I'm asking you, is it the doctor's on your instructions? You may or may not know, but I want to know whether you're being instructed on whether she is indisposed until Thursday. In other words, she can only testify on Thursday.
That's correct.
Not today, not tomorrow, but Thursday.
Thursday, yes. That's my instructions.
And the doctor's letter is going to tell us so on your instructions.
That is my instructions, Chief Justice. I don't know if ever there is anything that is required on her part, and that's what I can say up to so far. As per the recommendation of the doctor on Thursday, of course.
Thank you.
You're welcome.
Advocate Hassan.
Justice Masneki, we had hoped that in the time during which we agreed to stand down, that we'd have a medical certificate produced rather than having to rely on evidence from the bar. So we have some difficulty with that, but I don't think there's anything we can do to cure it other than accept the undertaking of my colleague that it'll be provided today. As far as the date of Thursday, we find ourselves in a strange position because we are told that there's medical opinion, and we're not in a position to argue with that. If the witness is unable, is due to ill health, to be able to testify, there's nothing that we can really do about that except ensure and seek to ensure that on the day on which she is certified to be available, that she will indeed be available. So the question then is, how do we ensure that that happens? And in my research, in relation to your question, I have not been able to find a case which empowers an arbitrator to issue a warrant, even if it's to issue a warrant and stay it. The arbitrator doesn't have the powers of a court, doesn't have criminal jurisdiction. And if one has regard to the scheme of the Arbitration Act, which is what I think is foundational to how we run this arbitration, and that's what should guide us. The Section 16, which deals with summons of witnesses, requires a party. It doesn't entitle an arbitrator to do so. It requires a party to the proceedings to approach a clerk of the court in order to have a subpoena issued. In the same regard, it would appear from Section 16, subsection 4 of the Arbitration Act that, again, it lies in the hands of the parties to enforce that. I will say that the statute regards the failure of a witness to remain in attendance where the witness has not been excused to be, the Act regards it in a serious light and creates an offense in terms of Section 22 of the Act, and specifically Section 22(1)(b) of the Act, which reads as follows: any person who, having so appeared, fails to remain in attendance until excused from further attendance by the arbitration tribunal shall be guilty of an offense liable on conviction to a fine or imprisonment. But that only takes us so far, because it tells us that the Arbitration Act does confer a solemnity to these proceedings, and that the failure of a witness to avail herself is an offense, is a criminal offense. What we do with it would require us to then report it. So it will...
But that wording is couched in exactly the same wording of the Criminal Procedure Act, isn't it? Go and look at subpoena of witnesses in the Criminal Procedure Act. What wording is used there for failure to remain in attendance?
It similarly creates an offense. The question is whether, what we do with that. The question is whether the arbitrator is thereby empowered to issue a warrant.
Well, who excuses a witness properly subpoenaed?
The arbitrator does. And it's clear from 22(1)(b) that the witness is to be excused by the arbitration tribunal.
And if a witness is not excused by the arbitration tribunal, what are the consequences?
I think my reading of the Act is that it then requires a party who subpoenaed. We are also talking about a witness who is subpoenaed. It's for the party who issued the subpoena to enforce it.
You see, tribunals never issue subpoenas. The magistrate's court, the prosecutor issues a subpoena.
Yes.
A party who would like certain evidence to be placed before the court can't get cooperation, may also cause a subpoena to be issued. So the Act does nothing that is unusual. Parties, courts don't issue subpoenas. Tribunals don't issue subpoenas. Parties do. even the criminal system or the civil system.
The difference...
So our only question is to understand what are the consequences of not remaining in attendance once properly or lawfully subpoenaed and appear before a tribunal. We are told it is an offense. So I'm saying to you, in what is the wording of the Criminal Procedure Act, for instance, on the same matter? And we can go and look also at the Civil Procedure Act and see what is the wording for non-attendance of a witness. Is it couched in the same language? That's important because it will help you understand what interpretation there has been up to now of failing to remain in attendance. What's open to the parties, alternatively what's open to the tribunal.
Justice, my understanding is that the further nuance is that whatever the Criminal Procedure Act may say, and I will verify the wording, my understanding is the court will have powers to issue a warrant. The question is whether an arbitrator under the Arbitration Act would have similar powers to a court in civil or criminal proceedings to do so. And so that's the basis on which...
Only vis-a-vis a subpoena. An arbitration tribunal doesn't have criminal powers in the same sense. It doesn't hear criminal trials. It does not have the power to be punitive in the sense of sentences. It's essentially a civil dispute resolution method. The narrow question is, there are coercive powers in the statute. How and by whom are they enforced?
So, Justice, this is what I'm trying to get to, because the scheme of the Act, as I read it, doesn't provide for coercive power for the arbitrator in these kind of circumstances. There are powers of the arbitrator and then there are powers of the court. So it also regulates the way in which this tribunal interacts with the court. For example, with in issues of service and discovery and other rules. And it regulates the interaction between this tribunal and the courts, which to me suggests that it's a court that would have the power to do anything as a result of the failure. Whatever we may do now, it would have to be through a court. It creates an offense, that's true, then it must be reported. There's also a question of practicality and the circumstances that are happening here. We're dealing with circumstances in which there isn't an unexplained failure of a witness to appear. The witness is represented and has counsel representing her. There's a reason that's given. We still believe that the basis is not laid properly evidentially, for example, through a medical certificate, but we accept the bona fides of this approach to the tribunal. So as a matter of practicality, given that this witness is represented and has given a reason that's based on ill health, in other words, not in her control, and they're undertaking that we will receive a medical certificate, I submit that it would be required that the counsel for the witness similarly provides an undertaking that she will be present at 9:30 a.m. on Thursday, and to do so as an officer of a court.
Well, if it doesn't happen, then what? I'm talking about the law, not about practicality. I understand that may be a practical course ultimately. We still might have to confront that issue. We might defer it maybe to And the other question is always whether undertaking of counsel is binding on the witness. Why is it? So, comes Thursday and we are here, we might have to argue the point again anyway. I don't see it going away. It may be a new point. It may be a point that was never decided before. But there would probably be case law on Section 22, is it? The one that creates the offense?
Yes, Section 22, 1B.
Yes. Is there any previous authority on that?
No.
It will hardly occur.
There's no case law on Section 16 or 22 of the Arbitration Act.
So it's a res novus. It
Indeed.
may well be an entirely new matter. Which is always subject reviewable before the High Court, always. But may entirely be a new matter. I don't know what it means. Would you read the section again, Section 22, 1B? In fact, I have the
22, 1B is any person who, having so appeared, Justice Moseneke, if you can excuse me for just 30 seconds.
Yes, certainly.
That's what I want to get there. Thanks. So 22, 1B is any person who, having so appeared, so A is, let me go through A and then B. Any person who, without good cause, fails to appear in answer to a summons to give evidence before an arbitration tribunal, or B, having so appeared, fails to remain in attendance until excused from further attendance by the arbitration tribunal, shall be guilty of an offence and liable on conviction to a fine not exceeding 100 rand or to imprisonment not exceeding 3 months.
Shall we, our case is a sub 1B, right?
It's sub 1B.
So my simple question is, how do you enforce sub 1B?
Well, the only way that I'm aware of that one can enforce a provision like that in similar terms is through issue of a warrant, so of arrest. And Section 170 of the Criminal Procedure Act, which deals, you've asked me to have a look at, is in similar language of 22(1)(b, in the sense of creating an offence. That is Section 170 subsection 1. But Section 170 subsection 2 says the court may, if satisfied that an accused referred to in subsection 1, it refers to accused, but later on Section 188 makes this applicable to witnesses as well. So we can read accused in this provision as a witness, has failed to appear at the place and on the date and at the time to which proceedings in questions were adjourned, or has failed to remain in attendance at such proceedings as so adjourned, issue a warrant for his arrest, and when he is brought before the court in a summary manner, inquire into his failure so to appear or so to remain in attendance. The same court may, unless the accused or the witness satisfies the court as to the reason for not remaining in attendance, may convict the witness of an offence such as the one in Section 22(1)(b). Of course, we're not there. We're just in the point of issuing a warrant. So that is the procedure that is followed in the ordinary course before the courts. There's a second thing, which is the Arbitration Act provides a broad parameters for a tribunal. It's also clear from the Arbitration Act that what determines a procedure is also the terms of the agreement between the parties for the arbitration. And so, were all of the parties before you to be in agreement as to how to resolve this conflict in a way that doesn't result in us coming back again and having, having round two of the same argument, then I see no reason why you couldn't exercise the power to secure the attendance through a writ, through a warrant. That might be another solution to the problem, which is all the parties are in agreement. We've heard from the witness's own representative that they have no objection to you exercising that power. There's nothing in the Arbitration Act that says you do not have that power. It's simply silent, and it has not been dealt with before by our courts. So we don't have any precedent to rely on. And in order to ensure fairness, as a basic principle that guides this, I would suggest that if all the parties are in agreement, then we take whatever steps that are necessary to ensure that we proceed on Thursday morning with the witness. I must add, Justice, that the families that are here and have been present throughout these proceedings are themselves taking some strain from from the non-attendance of this witness. And I don't want to fall foul of the rules by myself giving evidence from the bar, but I, in the interest of my clients, must say that it is causing some distress that they are being disrespected, and that it's a sense of a repeat disrespect.
Yes, that's what moves me. That's why I am wanting to resort to the law to make sure that we don't have abuse of process. That's precisely the point. And that's why I'm inviting argument before making or not making a decision, which is a prudent thing to do. You see, the Arbitration Act has a number of provisions, starting with the agreement of the parties. And where the parties haven't agreed on certain things, the Act itself fills in the gaps. But probably the most important part of the Act is a requirement that the arbitration shall be conducted in accordance with the law, with valid law of the country. So the agreement draws the ambit of the arbitration process. But the Act also creates offenses, as you've just pointed out. I'm happy to know that if you willfully insult me, you're committing an offense. And a few other things. So it actually, the law tries to protect arbitration processes, and if not set aside in all respects, they enjoy enforceability. So the question must be, if there is an offense created by Section 22, which I've opened up now, I'm looking at, together with many other offenses, if you refuse to answer fully and to the best of your knowledge and belief any question lawfully put to you, even that is an offense. So you can compel a witness and say, answer the question, like in any other proceeding. So it has been done to be a process that would arrive at, crafted by the parties, by agreement of the parties, at a time and place suitable to the parties, and create rules that are binding on the parties, but within the broader structure of the precinct of the Arbitration Act, which then, to help any other ADR form, people would have just walked away. Mediation doesn't have the same facilities.
Precisely.
You talk when you want to. Then you walk away if you don't want to anymore.
Precisely.
This, the law makes binding and creates a straitjacket that, with teeth of a penalty. So my question is, a witness is obliged to remain in attendance, having appeared, does not. Let's assume there is even a valid reason. How do you manage that? And if there's no valid reason, how do you manage that? here we are in the terrain of a valid reason, possibly. And that's the law I'm trying to get my arms around.
I understand.
Any further submissions you'd like to make on that?
Perhaps
I don't know if the parties could agree to give coercive powers to an arbitrator which are otherwise not present in the statute. I don't know whether they could be conferred. There are many things that could be conferred by agreement, it's obvious. But I don't know whether a penalty in relation to an offense created in a statute could be derived from the agreement of the parties. It's a difficult proposition to...
You see, Justice, and that's why the Arbitration, so the Arbitration Act, as you said, the reason that the offences are created is to protect the integrity of these proceedings, or else there would be no point to resort to arbitration, and to protect the solemnity of this process. This is while it's by agreement between parties that we engage in this process, the process itself is governed by law. And any award or ruling that you make is binding.
Yes.
On the parties, and that's akin to the powers of court. But the Act does something else. It also regulates the interaction between the arbitration tribunal and the court. When do you need to go to court to do certain things, and when can it be done by an arbitrator?
Yes.
And so, that's why my earlier submission was that it's not apparent to me, and certainly with the absence of any guiding case law, that the power is conferred on an arbitrator, that coercive power, to issue a warrant of arrest. And so, perhaps it's a conservative approach, but because the Act does more than just create the solemnity of the proceedings, but because it creates and distinguishes what may be done by a court and what may be done by an arbitrator.
And also it's a method of protecting the parties. The penalties there, offences there. You see, if witnesses could stroll in and out of an arbitration, parties have invested time, money, effort into producing an outcome, and people come and go as they wish in a way that affects the reaching a speedy solution. Or people come to an arbitration and spit and swear and shout, and that's why it creates these offenses.
Yes.
You're right, to protect the integrity. The narrow thing we are at is, how do you protect that integrity? Is it anticipated that a tribunal will every time rush to another court and ask for an offense has been committed, put this on the trial of the magistrate's court, which means that the entire tribunal will have to stop until there's been prosecution, assuming it comes to that. All of those may be relevant considerations on how you construe the power.
Well, what Section 22(1)(b) does not do is what the Criminal Procedure Act does.
Yes. Which is very helpful. It's express, it's clear, and it relates to the liberty of a person. So when it is expressly given, it's much, much more protected than when it is inferred.
Correct.
You don't take liberty by inference. Anyway, do you have any further submissions? You have many colleagues who...
Yes,
Yeah.
they might be of assistance to me
Very well.
and to you. Those are my submissions.
Thank you. Advocate Krause.
Thank you, Justice Musaneke. Justice, we have thought about this issue. We can't address you in any manner that will be helpful more than has already been said. We would want to suggest, as was indicated by my learned friend for Dr. Malamela, that you issue a warrant and hold it over until Thursday, and that these issues be deferred until Thursday to give us sufficient time to apply our minds and then address you on the issue. Those are our submissions.
Yes, and the warrant would be in the form prescribed where? In the Criminal Procedure Act or the Magistrates Act?
I suppose that should be, or in the High Court. It's the same issue.
Or in the High Court?
Yes.
And you'd approach the registrar and ask the registrar to issue the warrant? I'm just talking mechanics also.
I would submit, if you order the subpoena at this stage, but say that the execution thereof is still kept in abeyance until Thursday.
You can issue a warrant and suspend it.
Yes,
And
and
the
then on
party-
Thursday we can address you on the mechanics, which I suppose would be through the proper authority.
If Dr. Manamela comes on Thursday, we don't have to have the debate.
Absolutely.
If she doesn't come on Thursday, the debate will be, how do you operationalize the warrant?
That's our submission, yes.
I hear you. That is helpful.
Thank you.
And the interaction which Advocate Hassan was referring to between the statute, the arbitration tribunal and the court, it's always one where the court is approached to set something aside, which the tribunal might have done, or to make the tribunal's award an order of court. So usually it is a relationship where you either set aside something that, i.e., an unlawful warrant, or some such step that might be taken in a tribunal. But ordinarily, you don't midstream run to the court, except for a few specified instances. Help me, my witness doesn't come to the appeal tribunal. It may be that you conceive the remedy to be inside the statute, and if it is not authorized, somebody can go and find relief. And that ordinarily would be by way of review before the High Court. But in any event, let's go to Advocate Groenewald.
Thank you, Justice. Justice, we agree with our colleagues on the submissions made and the debate and the discussions with Justice itself. I think one point we would like to make is the fact that at this point in time we do not have any evidence to suggest that the failure of Dr. Manamela to attend the proceedings today is justified. We haven't been produced with any medical certificate, and the one thing that we suggest and what we say is that Dr. Manamela should actually come here and explain a non-attendance. She's now saying that, well, she has a medical certificate and she will produce that. There is a number of court cases that we have been able to peruse that suggest that the court, perhaps not arbitration proceedings per se, but the court's entitled to call upon that witness to appear, so for the magistrate to see whether or not the extent to which that individual is indeed ill. The long and the short of the argument being, Justice, that a warrant of arrest needs to be issued. There is no attendance by Dr. Manamela. There's evidence from the bar that she's ill. We haven't seen that. We are entitled to dispute that. We're entitled to dispute that the witness is not so ill, so not to be able to attend these proceedings. So we submit that the warrant of arrest should be issued. Whether or not she gives the commitment and the undertaking to appear at these proceedings on Thursday, we submit that so to ensure that these proceedings continue. It's in the interest of justice that these proceedings continue. It's the interest of justice that these family members hear the evidence of Dr. Manamela, and she is by law required to come and testify. So in summary, Justice...
In what form would the warrant be issued?
Well, what form of the warrant be issued? We submit that the similar proceedings be followed, as my colleagues have debated with yourself, Justice, through the High Court if necessary. And I cannot see on we have the subpoena. The subpoena has been issued through the High Court. It's a failure to appear here is not in compliance with the subpoena issued through the High Court. So we can't see why the warrant of arrest cannot also be issued through the High Court. We submit the support from justice itself.
Yeah. And you support the proposition that the warrant would be suspended pending occurrences on Thursday?
Justice, yeah, that's a debate. We do not mind that the warrant be suspended. We will agree to that. We will abide to that. In terms of the law, whether or not the warrant can be suspended, that's another debate, but the issue is more in respect of bail proceedings. But we will agree and we will abide
yes,
if
it's
it's
execution.
agreed.
You can issue a warrant
Yes.
and direct that it may be executed only after a certain event has occurred. That happens all the time in the courts. If somebody comes on Monday and shows that indeed they were so ill that they could not even come to the court and produce a medical certificate, then the warrant gets set aside. So the warrant gets issued in perfect form. Its execution is suspended pending a specified event, i.e. Thursday morning, 9:30.
We will be content with such proceedings, Justice.
Very well. Advocate Ina.
Thank you, Justice. Justice, we also support the application to have the warrant of arrest issued and stayed over until Thursday, in light of the submissions that were made by our learned friend, Advocate Mashilane. On the issue of form, our submission is also in line with what Advocate Groenewald has submitted, that because the warrant was issued by the High Court, therefore it follows that, I mean, the subpoena was issued in the High Court, it follows that the warrant also be issued in the High Court. We also submit that it will be, from the wording of the Act, it would appear that it's the court that would have the authority to issue the warrant. Yes.
Okay.
And also the definition of the court is contained in the Act, in the Arbitration Act.
Yes.
Yes, it excludes the arbitration.
It is the arbitration tribunal that would order a warrant to be issued, in other words.
That is
but the issue will be done
in the High
Yeah.
Court, yes.
by evidence leaders or any other member for that party through the
Through the registrar of the High Court. I suppose
To the registrar of the High Court.
Yes, in light of the fact that the Section 27 caused the subpoena to be issued, maybe it would follow that they also apply for the warrant of arrest.
yes.
Thank you.
Very well. Advocate Tutama.
Thank you, Justice. Our submissions are twofold. Firstly, we hold the view that the subpoena that has been issued against Dr. Manamela is still valid in light of the explanation given, for as long as it will be perfected by the production of the medical report. And in that event, her appearance on Thursday will still be in pursuance of that subpoena.
Well, Counsel, what do you say to the distinction in Section 22 of the Act? You have a look at the wording. It deals with two different situations. The one is where somebody fails to appear, 22(1)A, and 22(1)B is having so appeared,
Yes.
fails to remain in attendance.
Yes.
In law, those are two separate juristic acts, aren't they?
Justice, my reading of Section 22, subsection 1B, will have to be understood in the context of the inability of the witness to give reasons of the failure to be in attendance. If one reads that section in totality, it says that on conviction of that witness, then the court will then either impose a fine or issue a sanction of imprisonment. So what will then happen as a matter of course is that the witness will then have to be given an opportunity to explain that inability. Then the court will then...
I don't know, where do you read on conviction?
It's an offense.
We're still dealing with the interpretation of section 22, right?
Yes. If I can just read section 22(1) in totality.
Yes.
It says, that any person having so appeared fails to remain in attendance until excused from further attendances by the arbitration tribunal. Then if you go to the paragraph after paragraph F, which is a continuation of that subsection, it says that shall be guilty of an offense and liable on conviction to a fine not exceeding 100 rand or to imprisonment for a period not exceeding 3 months.
No, Councillor, let's read the whole. 2 deals with an entirely different thing.
No.
It's having made an affirmation.
We noted 2.
You knowingly give false evidence. That's perjury provision.
Is it the wrong section?
22(1), 22(2) is perjury. 22(1)(a) and B, 1, failure to appear. 2, having appeared, failed to remain in attendance.
I am reading section 22, subsection 1, subparagraph B, together with the paragraph that starts with shall be guilty.
And where's that paragraph, shall be guilty?
It's just below paragraph F.
But then you are in subsection 2.
No, Justice.
No. Okay, I'm sorry, let me read again. After F,
Indeed.
what is it numbered after F?
It is not numbered, like it is
Oh,
the
you mean shall be guilty of an offense and liable on conviction to a fine? No, like, you mean that part?
Yes.
Which is part of F, I see.
Yes.
I was looking below F. Shall be guilty of an offense and liable in conviction to a fine not exceeding 100 rand or imprisonment for a period exceeding 3 months, provided that in connection with the interrogation of any such person or the production of any such book, document, or thing, the law relating to privilege applicable to witnesses subpoena to give evidence to produce any document or thing before a court of law shall apply.
16.
So what part do you say should be read together? I'm a bit 22(1)B together with the middle of F.
Yes, like which states that if the person is found guilty for non-attendance, that person will then be liable, and on conviction, then the person will be liable to a fine or imprisonment. So what would ordinarily happen is that the witness will have to be convicted for having failed so to appear in line with section 22(1)B.
I don't understand that. These are different offenses. The offense in A is one, B is another, C is yet another. A is to fail to appear. B is to appear and fail to remain in attendance. C is refused to be sworn in or to affirm as a witness. D, if you refuse to answer questions fully to the best of your knowledge. E is to fail to produce any book or document. F, while willfully insult the arbitrator or umpire conducting the proceedings, or willfully interrupt the proceedings, or otherwise misbehave, then you are guilty of an offense. So these are 6 separate offenses, aren't they? Or do I misunderstand something?
Yes, Justice. Subparagraphs A to F, they are distinct offenses.
Yes.
And my submission is in relation to offense referred to in subparagraph B. Paragraph B, which says that after having been in attendance, then the witness fails to avail herself to the proceedings.
Yes.
So if you read the paragraph after the last offense, after paragraph F, then what it anticipates is that if the person is found guilty, then there are consequences for such an offense. And the consequence will either be a fine or imprisonment. All that we want to submit is that, apart from our submission, that the...
You say that the penalty provision in F applies to all the offenses.
Not in F, the paragraph after F.
The paragraph after F is 2.
No, Justice. If Justice can look at the statute, it lists paragraphs A to F as separate offenses. And all those paragraphs have to be read in conjunction with the paragraph that starts with shall be guilty. That's what we submit. Paragraph B does not need to be read with paragraph F.
So you say shall be guilty of an offense refers to all the preceding offenses.
Indeed so.
Yeah, strange drafting. So you say what is in the belly of F actually creates an offense from A to E.
Not in F, Justice, after F. Justice should ignore paragraph F in the reading of the offense in paragraph B.
Can I look at your statute? Does it look different from mine? Is yours also like that?
Sorry, our reading of section 22(1) is that it creates several
Yeah,
offenses.
I'm not inviting you to speak yet because there's somebody speaking already.
This is proper, I think.
Yeah, but it's the same as mine.
No, it's not. It's F, and then there's a paragraph after F.
I see.
If he doesn't appear, but if it would be an offense, he should be guilty. He should be convicted.
Well, Counsel, I'd like you to look at, can you ask your attorney, Junior, Obakeng? It might be a formatting thing by the computer. Look at that.
Does the computer given by Ubageng of any difference to what the justice was relying on?
Yes, it is different. It is different from mine. That's why I'm showing you mine.
Yeah, no. Yeah.
Can you see F? After F shall be guilty of an offense continues,
Indeed so. Yes.
unindented.
Yes.
So I was struggling with that to
Yes.
see.
Yes.
But I do see, once you indent it, it means shall be guilty of an offense, and that relates to all the offenses
All
from
the
A
offenses,
to F.
yes,
Yes, I agree with the submission now, I understand. On my formatting, you can see it's embedded in F itself.
I've noted that, Justice.
Okay, thank you. Please proceed. I understand that now.
So
Thank you.
what we submit is that apart from the submission which we have made relating to the validity of the subpoena, which has already been issued, then it will be upon the party who has issued the subpoena to approach court and apply for the warrant of arrest to be issued. And once the warrant of arrest has been issued, then that witness will be taken to have committed an offense. Can you check the offenses? And then once that person has appeared before court, then the court will then have to inquire into her failure to have appeared, and where a finding will then have to be made to impose the sanction as anticipated in the Act. Section 22 So what we say is that it's only in the event of a person having failed to appear before the tribunal that a party, in this instance, who has issued the subpoena, will have to apply to court. And it is the court which is authorized in terms of the Arbitration Act to issue the subpoena, not the arbitrator. And if one reads...
How do you apply to court?
If one reads section 16, which is should be the starting point, it says that a party shall cause a subpoena to be issued with subject to the same conditions as if the reference were a civil action pending in the court having jurisdiction. So like in that instance, it says that the subpoena will have to be issued as if it was a pending action, it was a pending civil action, and which authorizes the court to issue such a subpoena. Then like one will then have to consider what are the consequences of not complying with that subpoena. And those are provided in terms of the law. And we say that the arbitrator or the Arbitration Act does not confer upon the arbitrator to issue a warrant. A warrant will have to be in accordance with the law, and then in accordance with the law, that warrant will then have to be issued out of court. And in this instance, it will be the
out of court. I don't understand what you mean by that.
In this instance, the warrant will have to be issued by the High Court, which has issued the subpoena.
Yeah, that we understand, but let's not collapse issue and the power to direct that as a warrant be issued. You understand the difference between the issue is a formal thing that indeed it will have to be the registrar.
Yes. Well, in fact, like our
like in all tribunals,
yes.
Any tribunal, the registrar would issue the warrant. I'm not sure what the argument is. How do you differ from your colleagues?
Well, our concern is that, like, how far is the warrant going to take us at this stage when the submission that the failure is not willful, but is due to ill health? And we have been informed that a report from the doctor will be provided.
No, but don't you collapse two issues? We don't know that. We've had evidence from the bar. Okay?
Well,
so
yes.
Courts ordinarily protect their process by making sure they secure attendance of the witness. And that is done by means of a warrant if there's a default. Now go and look at the Arbitration Act, Section 22. Go to Section 16. I mean, you've had the argument from your colleagues. I don't know why.
Justice, in order to avoid prolonged argument, if justice moves from the basis that the explanation given is not accepted, there is no proof, then I cannot take the argument any further. I was arguing on the basis that there will be a medical report provided. So if that medical report is taken out of the picture, and then we take it as failure to appear, then I cannot take the argument any further.
Very well. Don't you agree it is failure to appear, and counsel for the witness says to us the witness is unwell, and we say we accept the bona fides of the statement, but we await evidence. It's just that simple. So there is no, you wouldn't press on me to make a finding that Dr. Manamela is ill, would you? I don't know. And I've not been given a medical certificate yet. Prima facie, a medical certificate would be an indication like that, right? Yes. So we have nothing but counsel saying to us, and accept what counsel is saying. But if we are to preserve the integrity of this process and to ensure attendance of the witness, the question is, what does the law require of us to do now? And I could not, without more, accept the evidence from the bar. I accept the assurance, and I await evidence.
Well, in that regard, Justice, we submit that as the Justice is making the point that what has been given from the bar is not accepted, then in that event there is no medical proof of the witness inability. Then in the absence of proof, we do accept that in those circumstances, then the party will be entitled to approach court to have the warrant of arrest to be issued, which will then follow, which the normal consequence of an inquiry will then follow.
Sure.
My submission, I take it was premised on a wrong assumption that the tribunal has accepted that the inability is due to ill health. So if that is disposed, then the process to be followed is to approach court for the warrant.
Understand. Thank you. Any further? So of course, also, the warrant route has been tendered by the counsel of Dr. Manamela himself. But even so, thank you for your submissions. Any further?
Yeah, okay. No further submissions, Justice.
No further submissions, very well. Well, you're making us work, Advocate. Here we are back. Do you have anything you have to say? The law requires me to give you an opportunity to reply.
Thanks, Justice Msenek.
When are we going to see this medical certificate?
I've given an undertaking that before the close of business hours, it would have had been sent.
Business hours today?
Yes. So
You don't need a messenger on a horseback. These days, an email does it in seconds.
Yes, in fact, we do have the email address of Mr. Van Dijk.
Or the attorney?
No.
Mr. Van Dijk?
Overking.
Oh, I see. Oh, Mr. Van Dijk, okay, who works in my office. Overking, yeah, okay.
Yes. So I seem to, I actually agree with the interpretation of Advocate Hutam that wherein a party has issued a subpoena against my client will have to actually go back to the High Court to get that particular warrant to be authorized. So I think that is in order, and I don't want to make further submission. The reason being that it will be only the court that will have powers if ever it has to find that my client had willfully decided not to attend, and only the court can sentence. On that basis, that is in order. No further submission with regards to that.
Very well. Where should the subpoena be served? I mean, where should the warrant was withheld? I'm sorry, I asked the wrong question. You urged me to accept your undertaking that Dr. Manamela will be here on Thursday, right?
Yes.
Very well. And therefore, besides issuing the warrant for her arrest and suspending it, we don't have to do anything. The parties don't have to do anything. She will be here on Thursday morning.
Yes, as per my instructions.
And she knows as fact that she will be well then, and she will be here Thursday morning.
No, what I can say as per the recommendations of the doctor is that she will be here on Monday, on Thursday, so to say.
What date will that be?
One can assist the date. 23rd.
Of which month?
Of November 2017. And the warrant can be sent to my attorney.
Yeah, if ever it has to be executed. As things are, she'll be here, so the warrant won't have to be executed because we'll hear her out, right? Okay. Very well. Any further submissions from any of the council? No. Clearly, Section 27 would take all the steps which are necessary to have the warrant issued, which will be withheld. In other words, not be given to a officer to execute, because we have an undertaking that Dr. Manamela will be here on Thursday, the 23rd of November 2017 at 9:30 a.m. Is that in order?
As your justice pleases.
Okay. Very well. You are excused, counsel.
Thank you very much,
We're going to
Justice.
see the void you have created, how to fill it up. Because it's, I don't want to say much will wait until your client is here. But many, many people who are here, who are grieving and who would like to find closure. And they'll best find it by hearing witnesses tell them what happened. So we hope and look forward to the time when we will see Dr. Manamela again and listen to her. Thank you.
Thank you very much.
Do we have any possibility of witnesses that we could proceed with in the light of the circumstances we find ourselves in?
Justice, from our side, our witnesses which we intended to call tomorrow are here. They feel they're not appropriately dressed. The court will excuse them for that. Then we can proceed.
Yes.
And the first witness would be Mr. Peterson, Mo Andrew Peterson.
Yes.
His affidavit is already before this arbitration as Eli 66. And he will take the oath.
Thank you. Okay.
Can I just get my jacket? If I have a jacket. Can I
Did
get the
you
jacket?
say 56, counsel? 5-6?
Sorry, Justice Musineki, 6-6.
6-6, thank you. Do we know who's in charge of the air conditioners? Obakeng, we should try and attend to that and get them working. They, during the break, we should just get them cooler than that, please. Can we? Now, I want you to leave them on. It's very hot. Just make them cooler, colder. Thank you. You may proceed, counsel.
The witness will take the oath, Justice Musineki.
Indeed. Mr. Peterson, would you please put your full names on record?
Thank you, Justice. My name is Mao Andrew Peterson.
Thank you, Mr. Peterson. Do you swear that the evidence you are about to give will be the truth and nothing but the truth? And if so, please raise your right hand and say, "So help me God."
So help me God.
Counsel.
Thank you, Justice Musaneke. Mr. Peterson, we're going to lead you on your involvement in three aspects. The first is with your family member who is a mental patient, a mental health care user. We are going to lead you in respect of the family committee and your involvement therein. And we're also going to lead you in your latter role as in the Mental Health Review Board. You understand it that way?
I do understand, Council.
Where are you residing?
I reside in Matrent, 1241 Boxwood Street.
Now, if we could start with the mental health care user, who is your family member, who is that?
The name is Victor Truter. The name is Victor Truter.
And how is he related to you?
He's my uncle by virtue of being my late mother's brother.
And tell the court, for how long have you known him?
I knew my uncle since I was 6, 7 years old. I've known him all my life, let me put it that way.
Can you explain that? Did you grow up in the same house? How did it happen?
Yes, Council. I was brought up by my late grandmother because my father was a political refugee and my mother became a self-imposed refugee to Lesotho. And so my grandmother had to take over when I was about a year old. And so I grew up with my grandmother in Alexandra Township. And in that environment, as I grew up, I came to the realization that I had a sick uncle. And in my childhood understanding, I thought that one gets sick and then you get well when you take medicine. But I eventually realized that this man is not getting well, he's just staying sick.
Okay, could you tell the court now, as an adult, what do you know is wrong with your uncle, Mr. Truter?
Well, he's got, I know now he's got chronic schizophrenia and that comorbid with hypertension as well.
Hypertension and?
Chronic schizophrenia, Council, which is more of the manic type, which means that he tends to be very hyperactive. He runs around a lot. In fact, in the township, we were known for two things: for my grandmother's Christianity and good deeds to strangers, as well as my uncle's random running around the township. So we were sort of almost stigmatized already at that stage.
I might have missed it, but I couldn't pick up how old is your uncle now.
My uncle
I just
will
said you have to have a very sense of what age a person he was.
Justice, he was born in 1948, on the 27th of April. If my mathematics is not let me down under the stress I'm under, then he should be turning 70 next year.
Yeah.
We are planning to celebrate him, so he's 70-year-old man now.
Your uncle, Mr. Truter, did he stay with you in the house when you were small?
My uncle, Umi, as we fondly call him, stayed with us in the house, but most of the time he would run around, and most of the time my grandmother and I either took him to somebody to pray over him, or to the doctors, or to the hospitals, and so on. He suffered from cerebrospinal meningitis as a child. I don't know how old he was, but then because of the status of medicine at that time, he wasn't timelessly treated, and being in the township and of a black stock, he was neglected. And so it turned into chronic schizophrenia.
Eventually, in 1967, he was admitted in Life Esidimeni, Benoni. Is that right?
That is true, Council.
And thereafter, he was referred to Waverley.
He was then referred to Waverley in Yes, to Waverley, yes.
In 1975, according to your affidavit.
1975, yes.
And has he been there since until the mental health marathon project?
Yes, Council, he was there. And we saw steady improvement in his condition. He became very, very stable. So much so, Council, that 10 years after my grandmother died, in 1994, one day I went with a newspaper to visit him, and he asked if he could read the newspaper. And I was quite impressed when he sat there. I still have the picture of him sitting there reading the newspaper. He was quite stabilized. His overactivity had calmed down, and he was beginning to orientate to time and space quite well, although he was still sick and needing care.
And overall, with what happened at Waverley, how did you feel about the treatment that he was receiving there?
We were very happy, Council, with the treatment he received there, because he had such a good improvement. We had our issues here and there with Waverley. They were by no means perfect, but I would say that we were 99.9% happy with the treatment, with the environment, and with his improvement over the years.
You regard yourself as the person that must care for him. Why is that?
Well, Council, I cherish the memories, my childhood memories of my grandmother enforcing on us that, to, not enforcing, but demonstrating love and care for strangers even and other people. But also she taught us to love him. I regularly went with my grandmother to visit him in Benoni. And also I cherish the memories of us as a family coming together with all my uncles who were staying outside of Gauteng, in the Free State and so on, coming together. So it was family reunion, and then we'd go and visit Omi, and we'd have wonderful times with Omi, and we'd even have a braai there. So for me, it almost became a culture, and I was looking forward to it as I grew up to go and look for him. But also, my grandmother, Council, left a letter she wrote, before she died, she wrote 3 letters to the family when she was about 70 years old. And those letters were quite in depth in terms of instructions and what we need to do and how we need to behave as Petersons, as Trooters, and so on. And also she stipulated there that we should always take care of Obi, that we should never forget about him. And she specifically said, Mauki, jy moet agter Omi kyk. If I may use Afrikaans from time to time.
Of course.
Okay. So the instruction was that you had to look after him. You understood your grandmother that way?
That is how I understood my grandmother, Council.
Okay. Now, if we can jump to December 2015, at the annual Christmas party at Waverley, could you explain to us what happened there?
Well, Council, when we arrived there, we were under the impression that we're going for the normal Christmas party, and we had taken some meat because we were going to have a braai, and we took some braai coal and other things, and food for Omi. It was myself, my cousin, and my aunt, who is his younger sister, his older sister. And when we got there, there was a huge commotion and there were forms flying around, and somebody was on a loudspeaker saying something. And later I realized this person is saying something about the center is closing. And so that was what immediately confronted me, Council. And eventually we were told by one of the managers there, Mr. Paul Mokwena by name.
Can you spell that?
Mr. Mokwena. M-O-K, actually, sorry, I wrote it down if I may just check. Mr. Mokwena is M-O-K-W-E-N-A. Koena, and also by Ms. Buthelezi. But actually, mainly Mr. Mokoena was on a loudspeaker to say that please sign the forms, take the forms, fill the forms in, and the center will be closing in March. It became quite clear to us that the center was closing, but there was no indication as to what was going to happen with all the patients.
What was going through your mind at that time?
We came in a high-spirited for a Brian. All of a sudden, the joy and all that was turned into pain, immediate pain and disappointment.
And what forms were being referred to?
Well, these were forms, apparently they wanted information and details about families because they wanted to know if some families could take their patients home. So this was basically an information form about the patient and about the conditions of the family.
Did you feel any pressure to take your uncle home?
Yes, I did actually. I must say, in the way in which it was conducted, the forms were almost shoved into people's hands, and the statement was categoric. And there was, in fact, Mr. Mokoena is a fantastic man, but he made it quite clear that I think you should take your families home if you can, because they had no clue what government or where government was intending to take these people.
What did you do with your form?
From what I can remember, Council, very vaguely, I think I destroyed it on the spot. I actually apprehended the mic. Well, I took the mic nicely from Mr. Mokoena, from Mr. Mokoena, and addressed the crowd. And there were a couple of other family members who supported me, who later became family representatives as well.
Why did you feel compelled to get hold of the loudhailer?
Well, I was also angry, Council. I was not just disappointed. I was angry at this inhumane way of being informed about such an important event. I mean, my uncle had been there for 40 years in 2015, if you do the sums, and it'd been okay. So it was like they're trying to fix something that's fine, You don't fix it until it's broken. And you don't do it that way. At least we'd expected they would have told us before we got there for the party.
What did you say to the crowd?
Well, I asked the people to gather together and to oppose this apparent close. And in fact, to find out if we could get more information about where exactly our family members would be going. And why it has to be in March. I mean, the first thing that occurred to me is March was just around the corner.
Was that the start of the family committee?
That for us was the start of the family representatives, yes, which eventually became the family committee.
Now, we're going to deal with this just a little bit later. I just want to finish with your uncle. Eventually, he was moved.
Yes, Council.
Do you know when that was?
He was moved on the 30th of May, 2016.
And were you at this Waverley Centre on the 30th of June?
Yes,
30th of May, sorry.
Yes, I was, Council, because I got a call a day before to say that my uncle will be moved. But let me just mention that 2 days before that, in fact, I'd organized for one of our pastors who's working with me at the Methodist Church to visit my uncle with my aunt. My aunt doesn't have transport, but pastor does. So the pastor collected my aunt as well as a friend in Rabbie Ridge who's also got a family member at Waverley. So they went for a normal visit. And then they were told that my uncle wasn't there because he'd gone for an operation. We didn't know about this. But then the day before the move, I got a call to say that the center will be, my uncle will be moved.
Okay. So you went to Waverley? Did you go alone?
No, I went with my cousin, Shrine.
What is his name?
Shrine Nolan.
And what did you find when you got there?
Well, we found patients being moved. We found patients all over. Some were standing in the sun. We found what looked like chaos, people moving around from backwards and forwards, some patients being taken to cars and so on. There seemed to me to have been no order there.
How many patients did you see standing around there?
Council, if my memory serves me well, I would say, and I'd estimate it's about 50 or so.
50.
50.
And you say some of them stood in the sun? Were they all mobile?
Some were not mobile. That broke my heart, actually, Council, because, I mean, I'd been up to, we just actually jumped the stage where I was involved with the department and engaging.
We'll come back to that. Let's just finish your uncle.
Yeah, but I was upset because some of the patients were standing there. Some of them, they were in wheelchairs. And some of them looked quite strained. And there was no indication of food. There was no indication of any doctors that I could see. And it looked chaotic.
Any water?
There wasn't any water that I saw in the vicinity. And what saddened me more is that there was a chap, there was apparently an entrepreneur and an acquaintance, I would say, of my cousin. And he had come there and he said he had heard that there was a business opportunity, an opportunity to get some people. You know, that really upset me because I said, what do you mean get some people? You know, these are people. These are not objects that you come and take and commodities, then you go and put them on the market or something like that. That got me very upset, Council.
Did the patients have any belongings with them?
Some of, sorry, I'm getting upset.
Take your time. We've got a lot of time.
Sorry, Council. Some of the patients had their belongings with them, yes.
In what manner?
Not all of them. I think they were in bags, Council, if I remember well.
Black bags?
Black bags, yes. Black bags.
Mm-hmm.
Did any belongings? Lots of belongings?
Well, some had lots, some had little.
But
my uncle had lost, he always loses his stuff, but he had some belongings with him.
But only enough to fit into a bag, isn't it?
I think it was only enough to fit into a bag,
Yeah.
Justice.
Did you speak to any of the patients?
Yes, in fact, I did. Actually, I ended up lending a hand. I mean, I found myself carrying patient files, and, you know, because this lady she almost dropped some files, and I helped her pick them up. And I said, well, can I help you? She said, yes, please put them there next to the bus driver, and put them there. But there was a gentleman there who really saddened me quite a bit, you know, and every time I think about him, I get quite angry, actually, because he was a bit disabled, he was limping a bit. And he was a white gentleman. And he said, sir, do you know where we're going? I said, no, I don't. He said, gosh, where are they taking us, you know? And I didn't have answers for him. I didn't even know where they were going to take my uncle at that stage.
For how long did this process continue?
Council, I have to admit that my cousin was a bit under pressure because he's running also his own little business that he's trying to get up and running. So he was under pressure, and I didn't have my own transport. I would have loved to stay there longer. But it went for, I would say, about 3 hours or so that we were there, that this
3 hours in the morning,
was
afternoon?
going on. This was from sort of late morning to late morning to sort of early afternoonish. I think if my memory assists me, some of the transport was leaving, and there were buses, there were mini buses. I saw also some vans there that were departing.
With patients in them?
With patients in them, yes, Justice.
When you left, was your uncle still left behind, or had he gone?
No, my uncle insisted that we should wait until my uncle leaves. We actually cleaned him up, and we dressed new clothes that we had brought for him. And so when his bus started moving, in the commotion, we forgot actually to ask the driver where he's going. So when it had gone, I still stayed over. But yes, I stayed over quite a while.
Did you try to get information from people around there where your uncle was going?
Council, I really didn't really. My memory, I can't remember asking anyone, and even now I can't figure out why I didn't actually ask that. But I think I also assumed that some of the things would be done by my cousin, because he was busy also talking to the drivers at one stage, and I assumed he knew where it was.
Could
really
your uncle walk on his own?
Yes, Council, but yes, Justice. But because of the operation he had a couple of days ago, he was limping.
Did he get onto the bus himself?
I assisted him as well as other patients to get onto the bus. I must say I was unhappy because the buses was quite squeezed. They really packed the patients tightly, you know, and I complained about that and said, look, this is not fair. A rather bit of an irate nurse, I can't remember if it was a nurse or somebody, you know, said, please, sir, you are obstructing our work here. We're trying to work to get the patients out of the way. I can't remember how I responded to that.
Now, how did you find out where your uncle was taken?
Councillor, as I said, at that point I was already engaging with the department, and I'd actually even visited some of the sites, and I know we'll come back to that. Sorry, Council, the question again.
Okay. How did you find out where Mr. Trutte was taken?
I never really knew where he was taken at that stage, or even later on, because when I had a meeting with the department, and they, I asked them where my uncle had taken to. They didn't seem to have a clue. I also called Waverley directly, but didn't somehow get that information out of them.
Was there any answer at the telephones at Waverley?
There wasn't any answer at some stage. I think at some stage there wasn't any answer. Initially there was, but it was just, I mean, no answer, but there was a ring. But I think later on there wasn't even a ring going on.
So what did you do?
Because I was already talking to Mr. Musenoche, sorry, and other people, Dr.
I had warned that it's a kind of error we shouldn't make.
I greatly apologize, Justice. Please see my apology. Musenoche.
Musenoche,
yes, yeah. Mr. Musenoche and also Dr. Manamela. I've been talking to them, I've been engaging with them. So I actually tried to find out from them. They couldn't give me a clear answer. They said it was either at Sterkfontein or Baneng.
Did you go to Sterkfontein and Baneng? Did you contact them?
I didn't go myself to, my cousin went, but I didn't go. I contacted them several times, but we just couldn't get hold of my uncle.
Was he at Baneng or Sterkfontein?
Well, later on, I'm told that he was at Baneng, but it's still not sure whether he was at Baneng or at Sterkfontein or some other place.
For how long was your uncle missing?
Approximately 2 months.
And where did you find him?
Eventually, I was told by somebody at the project team that I should look for him at Mosego. And the argument was that they'd probably taken him to Mosego because that was quite close to Midrand, where I reside. And so that's how I got to know where he was.
Did you go to Mosego?
Yes, Council, I did go to Mosego.
And what did you find there? Was he there?
He was there indeed, Council.
Now, it's 2 months after you've last seen him. Did he still look the same as that he looked at Waverley?
No, Council. He didn't look the same.
What was different?
Well, he had lost a lot of weight. He was totally thin. I have we have a culture of hugging my uncle. You know, we give him a hug. And I gave him a hug, and my heart just sank because what I touched was a skin and bone. And he was dark. I mean, he's a fair-skinned person. And he was very dark, and he was obviously very dry.
He was?
He was obviously very thirsty as well, and hungry. And he was in pain, Council. He was in pain, and I said to him in Afrikaans, Oomie, wat maak hier jou? He said, my been is seer.
Okay.
I still thought it was an operation.
My wat is seer?
He said, my
rug.
thighs.
Oh, my been is.
My been is seer, yeah.
And did you look at that?
I didn't quite, Council. I didn't check that. I asked the caregiver who was there, who was around there, and I asked her, I said, what's this, my uncle? Is it his operation or what? Why is he in such pain? She said, no, in fact, he has a boil, an untreated boil.
And did that go septic?
My cousin checked. And he was brave enough.
You didn't
to
have
check.
the stomach
I didn't
to
have the
check.
stomach to check. He checked. I love, you know, we both love Umi a lot, you know, and it was just going to get me very angry. But he checked and he said, "I like nie mooi nie. I like regtig nie mooi nie."
It didn't look well.
It didn't look well. Yeah.
Was he clean?
He wasn't clean. He was very dirty. He was scruffy. It looked like he was in some sand situation or something like that.
Why do you say that?
Well, because he was, as we say in Afrikaans, asphalt. He, you know, he looked like he had a sandy look, but you could see his skin was dark, and it's not his normal skin. But he looked like he was.
Tell us about his hair.
Well, his hair was unkempt, Council.
Was there sand in
there
his
was
hair?
sand in his hair, yeah. I remember brushing the sand out of his hair and saying, Oomie, what did you do? What did you know do? And he said, yeah, niks nie. And then I brushed him off like that. But I mean, he was just in pain, and he was...
And how was he smelling?
He smelled very badly.
Why do you say that?
Because, I mean, as I say, I give him a hug. And we were close to him. We could smell that he hasn't had a bath for ages. And I asked the caregiver, I said, why are they so dirty? Why is he in so much pain? And the caregiver at that stage, and I said to her, look, he looks very sick. She said, well, you can't blame him. We haven't given them medication for quite a while. That's what she said.
Does he need medication?
Yes, he does need medication, Council.
And the bathing, why did that not take place? Do you know?
I have no clue, Council, because when we went as part of the team, the family committee, family representatives, to Mosego, they showed us some ablution facilities, and they seemed to have showers there. But I think it's just indicative of this whole project, which just was full of neglect, not caring, same as what we saw today. People not caring, people not turning up, disrespecting the judge and the system and justice as a whole.
Could you see any activities going on there at Mosego?
I saw...
Sorry, Mosego.
Activities, can you please explain, Council?
Were the patients engaged in any activities there?
No, in fact, Council, that was one of the issues we raised with Mosego. One of our gripes was that there's not much space for activities there. So I didn't see any patients. In fact, I've got pictures of patients simply hanging around in the sun. And there were 3 other patients that came to ask for food because my uncle was extremely hungry. We needed to get him food immediately.
Let us just stop there. Before you went there, did you buy some food for him?
Yes, we did, actually.
And did you buy a lot of food or little food?
No, Council, we didn't buy a lot of food, Justice, because my uncle had now come to a point where we knew that he doesn't eat a lot. He used to have a high appetite, but over time and with him getting much better, he didn't have such a big appetite.
Where was Musecho?
Musecho is in Krugersdorp.
Geographically, in
In
Krugersdorp.
Krugersdorp, yeah. It's in Okkerse Street, 25 Okkerse Street in Krugersdorp.
Was it a home, a hall, a school? What was it?
It's an urban environment, Justice, which was converted houses which were somebody rented out to in order to use for this purpose.
Yeah.
You took some food to him, and what happened?
Well, we took only 2 pieces of chicken, and then we also took something to drink and some rolls. But to my surprise, he was so hungry. He just finished all that food. He almost ate the paper with the food. I had to stop him and say, Omi, wag. He wanted to eat the paper as well. I looked at my cousin. I said, you know, and my cousin looked at me and said, I thought you were talking to these people. I said, we tried to stop them from bringing the people out here. You know, guilt started coming in and all sorts of things. We had to go back and get him some more food so that he could eat. And then we bought some food there were 2 or 3 other patients there as well who were asking for food. But they were promptly pushed away by the caregiver who was there. And then when I brought the food back, I said, look, can you please bring those other patients? Because they look very sick and they look very hungry. And then I gave her the food. She said, never mind, I'll pass the food on to them.
Okay, we will deal with Masehu just now. Did you visit your uncle after that again?
Yes, Council, I visited my uncle 2 weeks after that again. I also stayed in telephonic contact with Masehu about his condition and what was happening there, and expressed my displeasure. We had a meeting with the department the following day. It was a Sunday when I visited my uncle. On the Monday, we were supposed to have met at Rissik Street. Department changed the venue from Rissik Street to BOL without informing us. But eventually we got to BOL, and when I got there, I was very upset. I'm a man of the collar.
Can you put some date to that?
That was, I visited my uncle on the 30th. If my memory serves me well, I think it must have been either the 1st or the 31st.
Of which month?
Of
May.
Of
July.
May, of July, sorry. No, that would be June.
He was missing for 2 months, and
Yeah,
you
sorry,
saw
July.
him going.
Yes, July. Sorry about that.
No problem. So it's July.
Yes,
Yeah, okay.
it's July.
For that.
Can I just go back to your uncle again? How was he dressed?
He was dressed in some clothing we both my cousin and I didn't know anything about. I mean, it was oversized clothes, they were dirty clothes, and we actually inquired about the clothes because when my uncle left Waverley, we had put a suit on him. We had bought some new clothes. I still have the picture where he's wearing the suit, because I took some pictures on the day of the move themselves. But he'd lost all that clothing as well, and he was just in some normal, filthy clothes, really.
And eventually he was moved from Masejo.
Yes, he was eventually moved, but that was only with the relocation. I went to see him after that July. Saw him in July again, and I saw him in August. I saw him regularly, and every time he still looked bad, but the boil was now treated, and he wasn't in pain, but he was very hydrated and thin. I also went back in December.
Was he dehydrated?
He was still dehydrated, yeah. I went back again in December before Christmas. We went there, the usual Christmas visit. I have pictures of us and the rest of the family, cousins, uncles, whatever you, there visiting him.
Yeah,
and
but we don't have consent to use those photographs. So was he still thin at that stage?
He was still thin at that stage, Council. In fact, if I may add, Council, he was thin until the following year when I went back with the rapid assessment team with Dr. Leslie Robertson, or the psychiatrist on site. She went and actually did a thorough check on him, Justice, and she still found him dehydrated and suffering from what she called temporal dehydration, which is
Are we going to go
most
back to the
serious.
meeting, Council?
Yeah,
The meeting of July.
I just want to pass the family member, and then we will go to that. Mr. Peterson, and then where is he now?
He's now, since the 5th of April 2017, at Selby.
And how is he cared for? Are you satisfied with how he's cared for?
He's cared for very well. He is improving, but you know, his weight is still not where it used to be. But he's fairly happy there. And I'm talking now as a committee member as well, we do have reservations about Selby, about the fact that it's still very much a constricted environment, but he's getting clinical support, he's getting his medicine regularly, he's getting good nutritional food. As a committee member, I went in there, we went in there to go and look at the kind of food and nutritional and diets that they give them and so on. We actually made a bit of noise about the fact that they didn't have enough OTs, which they did step up.
OTs being?
Occupational therapists.
Yes.
So that situation was remedied. There's still some work to be done, but at least he's safe and sound, and we're happy.
But between July 2016 to April 2017, where was Mr. Truter?
July.
You went to see him, you were unhappy.
Yes, sir.
And you required a meeting with the department.
Yes.
This was around July 2016.
Yes.
The next step you told us about, the 5th of April 2017, he was moved to Selby.
Yes, yes.
So my question is, where was he between July 2016 and April 2017?
He was still at Mosego, Justice.
And has he gained weight now?
No, he's not what he used to be, Council. You know, what was developed over 40 years or so of stay of him and care and love and good food, the repetitious, whatever it was called, marathon team managed to bring that down to zero, and we're still struggling to get him back to where he was.
Thank you. Let us now go back to your involvement in the family committees. So your first dealing was on the 5th of December 2015.
Yes, Council.
And on that day, did you sign a petition at all? What did you do?
Yes, Council. On the 5th of December,
2015.
2015, yes. Some of us came together and we agreed that we were going to oppose this, or at least get more information, or the least retard, slow down the whole process. So I think there were about 5 or so people that came together. But we asked family members on that day to sign petitions to say that, you know, they don't want the center. And this was at Waverley that happened.
And what was the next engagement you had with the department?
The next engagement was with...
I'm sorry, on the 5th of December, what engagement did you have? I mean, all I heard was you went on like a rampoker and you took the hailer and you said something, but what engagement did you have with government then?
No, we had no engagement with government. At that stage, Justice, we were engaging with the management of Waverley, Paul Mukwena and Matron Buthelezi. That was our engagement. And we communicated our sadness, our dislike, our disgruntlement with what was happening and the way in which it was happening and the way in which we were being treated with disrespect. And that was the core of the, also the petition that we signed. And we then decided as a family we would then meet again just before the end of December. But that meeting actually never took place. of the representatives. It only happened in January.
What did you do?
Well, several of us went to Mr. Mokoena, to Waverley, and Mrs. Buthelezi, and we went there to just make sure that the petitions are in and that they are communicating with the department, and that they would let the department know that families are very unhappy, and the families are against this draconian style of treating mental health care givers with absolute disrespect. So we were there with them at a meeting, and then we asked them to set an appointment with MEC.
And then?
We then did have an appointment with MEC that happened in February. Was it
2016?
January? Sorry, 2016. Yes, January 2016. January 2016, we then had a meeting with all the family. Most family members came. The meeting was scheduled to start at 12 o'clock.
Where was this meeting?
It was supposed to be at Waverley Council.
And who was the MEC that you were meeting?
It was MEC Gwen. No, it was MEC Matlangu.
The meeting was supposed to start at 12. What happened?
The meeting was supposed to start at 12, but some of us got there a bit earlier, again, just to consolidate, strategize, and voice our displeasure. Families were very vocal, Council. Families have always been vocal. Families have always been against this. These families really care and do love their loved ones. That I'm certain about. And we then caucused and we waited then for the meeting. In the meantime, apparently she'd sent through some forms similar to the previous ones. Again, similar forms about, you know, where do you live, what's your income, forms about the family and also about the patient and so on.
Who distributed the forms?
The forms were, I think, if my memory serves me well, Justice, those forms were distributed by Mr. Mokoena, who was the management of Waverley.
Yes.
Yeah.
Forms being distributed, what happened then?
Yes, then we were then obviously waiting for MEC Matlangu, who didn't turn up. And then families were very irritable and irate, and they said, look, why must we wait up? Families had taken time off, Justice, from work. It was during the week, it was during the day, 12 noon. Families had made arrangements at work just to come to this meeting, and she didn't turn up. Instead, she turned up at 2 p.m. And at that stage, some of the families had to leave. You know, they took my numbers. My numbers were taken by many of the families. You know, my cell phone number, and I had sleepless nights after that. With my phone ringing at awkward times, and many times I didn't complain about that because I realized the importance of this whole project.
Yes, and when she arrived, what happened?
Well, she arrived at 2 p.m. with her entourage, and I think Mr. Mosenoche.
Mr. Noche?
Yes, yeah, he was there.
We speak the same language, but we don't have the same surname.
I've been to I stayed in Lesotho for 5 years, Judge.
Okay.
Speak Sotho fluently. Yeah, she came with the entourage basically, and they came in there and wanted to start the meeting. And, you know, the family members...
The remaining family members.
The remaining family members asked her to apologize. We had to actually ask her to apologize. So why are you coming late? You know, people were very vocal. People were vocal to the point of rudeness. You can't really blame them, the council, I think, after the way they had treated us. You know, she treated us like we didn't matter. She treated us like we were second-class citizens.
How many people do you estimate were there?
If my memory serves me well, Justice, I would say maybe close to 100 people or so.
Did she apologize?
to be frank with you, Council, I don't remember her apologizing. But somebody said she said something under her breath about being sorry. But it didn't communicate that with her. And I think for me, this is where the word demeanor means a lot. Because her demeanor was that of somebody who was doing us a favor. She's a high official. And you know, we down there, and she's coming in and she's doing us a favor. That was her whole demeanor. So even if she said, I'm sorry, I don't think her body language communicated that, Justice.
And what happened at this meeting?
Well, what happened at this meeting is that she tried to tell us what was happening. That the center, that the contract was terminated, and government had decided to terminate the contract because it was far too costly to continue that. But she hastened to add that we shouldn't worry because they are taking our patients to better places. In fact, the patients will get the same treatment, if not better. And I remember I asked, you know, where are these places? Are they NGOs or the hospitals? Well, she said we have some very good NGOs, and we have some good hospitals that have got empty beds, and we're also building a new NGO. Apparently, she said. She said, and you know, the issue was, our main issue at that point was why, you know, because Waverley seemed to work quite well for us. And argument was, this is modern trends in de-institutionalization. The whole world is going that way. Patients are being moved closer to our homes. We'll have our patients closer to our homes where we can visit them frequently and where they will be taken care of very well.
Did you believe her?
I didn't believe her, Council. And I didn't believe, and none of us did, that it could happen in 3 months, even if it would happen. At that stage, I knew next to nothing about deinstitutionalization or the policy frameworks of the department and so on. But I just instinctively, all of us knew that this was disaster in 3 months. Because one of the questions that came out was, can you tell us who these NGOs are? She couldn't. We asked for at that point, we even asked for, have you got a project plan for us? Or something like, to tell us how this is going to unfold in 3 months. And she couldn't give those answers. And the meeting basically ended in a bit of chaos because some people walked out on her. Remember, it was already running late as well. And people were really angry with her attitude and her whole demeanor.
What was the next contact you had with the department?
Well, the next contact was, should I mention the marches?
Yes,
now? Yeah, we went on a march. We organized the march in February with the help of Section 27, and SADC was involved as well, if my memory serves me well.
Where did you march?
We marched from, again, if my memory serves me well, I think we marched from Mary Fitzgerald to the department's offices to express our opposition to this random haphazard move.
How many people marched?
There must have been over 60 people or so, Council, who marched. I remember one of our leaders, one of our representatives that worked closely with us as a family representative at that stage, he had a baby on her back. She had a grandchild. She'd just gotten a grandchild, and she had a baby on her back. People were quite committed and vocal and felt very strongly about it.
Do you have any placards?
We had placards, yes, we made placards, yeah.
What did it say?
Well, it said down with Getani, down with the Marathon Project, all in the same vein, really. I think there were some nasty paintings of her as well, if I can remember well.
Did you hand over any document to the department?
Yes, we did hand over a memorandum, which we handed over. I can't remember who received it though at the department, but it wasn't MAC.
And what was the gist of this memorandum? Do you know?
The gist of the memorandum was that we're opposing the move, we're against the move, and that the families should not be moved. Because at that stage, we were a bit more educated by Section 27 in terms of what was happening, their court cases, and how they'd been fighting this battle as well.
And when was Which month was
It was
this?
in February 2016, Justice.
February 2016.
What happened after this?
Well, after the march, basically, the department then somehow got hold of our names as the so-called activists or those who were vocal. And I think that that's when we began to team up also with the Renfontaine group. And then she invited us, there was a meeting to which we were invited by Dr. Malebane.
Celebana.
Celebani.
When was that?
Sorry?
Do you know when that was?
I think if my memory serves me well, it wasn't long after the march. I don't know exactly, I remember the exact date of our first meeting.
And where was this meeting?
This meeting was at, if my memory serves me well, at the Resik Street, number 1 Resik Street, which is where they were.
And who attended?
It was basically the whole project team was there.
What does that mean? The whole project team, what does that mean?
Well, MEC wasn't there. Mr. Musenoche was there. Dr. Malebane was there. Celebani was there. Yeah, there were some social workers there as well. There were several people there. With
Dr. Manamela there?
Manamela, sorry, I wanted to say Dr. Manamela, yes. No, Dr. Manamela was there. Pardon my forgetting her name. She's irritated me a bit this morning.
And how many family members were at this meeting?
I think there were 4 family members at that particular meeting, Councillor.
And what was the gist of the meeting?
The gist of the meeting was, for us, we wanted to just articulate once again our opposition to this move and then to get more information. But apparently they had an agenda. I think we ended up with 2 agendas. And then we actually merged them. But they wanted just to tell us about the project. They wanted to tell us about the whole concept of deinstitutionalization, which is a global process, and so on. So that was the gist of that, I think, the first meeting. But we had several meetings.
We'll get to that. Just as I see it, it is 13:30. If
it is indeed a good time to adjourn. You are also a pastor, Mr. Peterson.
Justice, let me make that record clear. I'm an ordained evangelist with mandate, Royal Mandate Ministries, because I spent 5 years doing my theological training. And that meant that I'm in
5 years?
I spent 5 years studying Christian
ministries. It's almost
ministries.
how long it takes to train a doctor or a lawyer or an advocate.
I am humbled by that. Yes, I did do that. Justice.
So you are a pastor?
I am currently in the Methodist Church where I'm involved and part of the leadership with the healing team, as well as in the pipeline for deaconship. They have a very long process and is quite a long process. But my qualifications are from abroad and not with the Methodist Church necessarily. So I'm not really technically an ordained priest. I must make that clear for the record. Yet.
Yes.
But I am an elder at the Methodist Church, and I have been ordained as an evangelist, yes.
We might need prayers here, and so...
Hallelujah.
Yes, please. I think it's the right time to adjourn. We'll resume at 2:30. Thank you.